Welcome to the Napa Legal Weekly Podcast. I'm Mary Margaret Bush, Napa Legal's Executive Director.
And I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal. You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty through the lens of faith-based nonprofits. This week, we'll be covering an interesting lawsuit between a religious nonprofit and a tech company over alleged religious discrimination. Mary Margaret, I'm really interested to hear you on this one, actually. Then we'll cover Georgia State University's recent decision to allow a Christian minister to speak with students on campus. And then we will conclude with some updates at the state and federal level regarding the ongoing debate over various transgender procedures and drugs for minors. So with that, let's go into our first topic.
Thanks so much, Frank. Yes, this first case is a very interesting one. The case is represented by attorneys, including some attorneys from ADF. And the case is called Holy Sexuality versus Asana. And this was filed on February 18th in the Southern District of California. So, to tell the story a little bit here, the plaintiff, Holy Sexuality, is a Christian nonprofit that focuses, as its name suggests, on teaching young people and families biblical principles of sexuality. It was started by a man who is a Christian and went through a phase where, as he puts it, he put his identity as a homosexual man above his identity as a child of God. That's how he described it. And the fruit of he ended up in kind of a downward spiral, including spending time in federal prison, but discovered the Bible in prison and was given kind of this a heart for this ministry, and which he began undertaking after he was released. So Holy Sexuality, like so many Christian nonprofits, they're looking to save money on operations, on overhead, and there's a 50% discount that this company, Defendant Asana, which is San Francisco based, they have this discount for nonprofits. So you can get the project management software at, I think it's like $12.50 a month instead of $25. And there's just one condition. They give this discount to any nonprofit that can show it's a 501(c)(3), unless it is an organization that's religious in nature. And this prohibition on giving the discount to religious organizations is categorized aptly under the organization's religious discrimination policy, which does exactly what it says it does: discriminates against religious people and individuals. So, Holy Sexuality, with its attorneys, challenged this policy under California's UNRRA Civil Rights Act, which provides that all people in California are entitled to full and equal treatment from businesses. And the complaint goes on to explain how problematic this discount structure is. I thought it was really interesting because I've actually come across this discount structure from this organization, TechSoup. TechSoup has probably 60 different software companies, from Microsoft to fundraising software. I mean, a lot of significant discounts that are available, but not if you're religious. So it's quite a radical situation, and I'm looking forward to seeing this case develop. A couple of points I wanted to make was just firstly, this is a case under California statute, so there are not First Amendment claims being raised here, and that's uh, primarily because this is a Asana is a private party. So the First Amendment applies against government actors. This is a private party or allegedly discriminating against another private party. So I think that's the first thing that's interesting, even though these are kind of free speech issues we normally associate with the First Amendment. And we kind of see the same kind of issue with some of the social media providers, some of the conversation there, like, well, are these private actors? The First Amendment doesn't apply to them, but there are certain goods that are described in the First Amendment that really belong in any place of public, the kind of the public square in general. So how do we want to bring First Amendment freedoms into the public square without crossing the line into undesirable excessive regulation? So I think that's really interesting. And then the second point that I think is interesting is, I think in some cases, this situation where you have a private party opting to allegedly discriminate against another private party, sometimes these are compared to like Jack Phillips or Baronell Stutzman's cases, saying, well, you have a private party declining to provide services to another private party for reasons of its own. Well, I think on its face that can sound a little bit persuasive, but when you really reflect on it, you realize there's some key distinctions. So this is actually quite distinguishable from the Jack Jack Phillips case and the Baronell Stutzman case. The first is, I think, the distinction that there's been no blanket denial of services in either Jack's or Baronell's or 303 Creative. There's no one saying, "Hey, I don't serve any people with brown hair." It's specific. Declining to engage in speech is really the distinguishing thing here. So no one's saying Asana needs to put like a Christian or Jewish or Islamic flag on their website. No one's saying they have to speak, but they are saying you can't treat organizations differently, less favorably than other organizations because of their religion. Just and it's just so blanket. It's just this denial over across the board. And then the second is that there's no sincerely held religious belief animating this behavior. So there's no allegation that Asana is a Christian organization and is declining to provide this discount because of its Christian identity or whatever the parallel might be. This is just they just care not to um, they care not to serve religious organizations in this way. And so I think those two distinctions, that the speech element, that this is not a speech, this is just a blanket denial of services, and then this is daily held religious belief, distinguishes from some of the other private versus private party kind of culture wars, so to speak, cases that we've seen. So this is a really interesting situation and one that I look forward to um, watching progress. What are your thoughts on this, Frank? This is a really interesting situation for so many reasons.
Yeah, I think it's interesting first because it kind of flips the typical story on its head, like you mentioned with like Jack Phillips and with 303 Creative. And I think it just kind of exposes the problem, right? You have the First Amendment, which obviously prohibits viewpoint discrimination or religious discrimination from government actors, right? But like you said, these are private actors, so this is a different realm. These are covered by statutes. But the thing is, the this regime of non-discrimination statutes that's been I mean, what, 60 years plus? The Civil Rights Act was 1964. The state level, they've been passing them for decades. So this is a policy choice, right? It's not constitutionally required, but it's based on some constitutional principles, like you said. And what it's doing is saying that, like, no, even if you're in the private if you're a private actor, if you're offering certain services to the public, then you don't get to discriminate. Now, I will say that's a policy choice, right? Like states and the federal government could have chosen not to go down that road, right? To continue a general marketplace where businesses are free to just do business with who they want and not do business with who they don't want. Um, that's constitutionally tenable, right? But that's not the path that we've gone down for 60 years. And when the shoe's on the other foot, they've made that quite clear that it's unacceptable, right? If you're baking cakes, you are going to bake the cake for the same-sex marriage. Or if you're designing wedding websites, you are going to design them for same-sex couples. But then when the shoe's on the other foot, it's just interesting to see something like this, to say, well, no, we don't give these discounts to religious people. It's like, well, yeah, this is the regime that has largely been, in the proper sense, a liberal uh, policy choice for decades. So it's just I think it's kind of interesting to see what happens when it plays out on the other side. The only other thing I'll point out though is I was looking at, and I didn't dive too deeply. I haven't read the whole the complaint from Dr. Yuan, but just from reading Alliance Defending Freedom's media release after the lawsuit, it seems that I think it's questionable whether Asana is even following its own policy here, because when they right they Asana said, no, we have this religious discrimination policy which refuses, now I'm reading off the ADF website, which refuses to provide the discount to any, quote, religious organizations that exist to solely propagate a belief in a specific faith. So putting aside the fact that that probably violates California's non-discrimination law, right? To target somebody who propagates one particular faith. I don't think that's really what holy sexuality does. Like the way that I see it, that's a ban on, a discount for basically like evangelization efforts. Like we exist to promote the Baptist faith, or we exist to promote the Catholic faith and make people Catholic, right? Holy sexuality is about providing like resources for families and individuals to embrace biblical sexuality, which is not actually propagating a particular faith or denomination. So I just think that's interesting. I think even by their own logic, their policy shouldn't have denied the discount to holy sexuality.
Yes, I think that's a really good point, and it sort of there are several contradictions in the fact pattern that I think further undermine sort of what Asana is doing here. And it kind of segues well, Frank, into our next topic, which I think deals on the same issue, kind of the intersection between the First Amendment, semi-public, semi-private institutions. So tell us a little bit about what is happening at Georgia State University.
Yeah, this is one of those stories that kind of like boggles the mind that it's real. I don't mean to be too, I'm not exaggerating. It's just a very surprising story that when you look at the fact pattern. So for people who don't know this story, very briefly, I'll go over the facts. So late last year, I think it was December when there was actually an arrest made, but there's a man named Stephen Atkerson, who's a Christian who would regularly go to Georgia State University. And remember, that's Georgia State University. So that's a public university. That matters. Stephen Atkerson is a Christian who would regularly go speak with students on campus about his faith. And it's clear that he would go discuss his beliefs with students who wanted to discuss. This is not like a street preacher with a megaphone, like yelling at people, forcing them to hear, or harassing people or anything like that. It was a very, low key approach. And if students wanted to engage, he would engage. Now, Georgia State had this policy, again, public university. So this is public space, right? So they have a policy that they can own that Stephen and people like him who are doing this kind of work can discuss their beliefs with students only in specified free speech zones. So on one occasion last year, Atkerson and another student that he had met, they were talking. They had talked several times before. It was raining, right? They're in this free speech zone and they're being rained on. So they agree to go find shelter. So they leave the free speech zone and they continue their conversation. I don't remember if it was at like a cafeteria or it was some still public space on the university, but it was not a free speech zone. So they left their free speech zone, and apparently university personnel, including armed police officers, approached them and told them that they had to move, that they could not speak outside of the free speech zone. These are really the facts. It's again, it's kind of shocking. So the update is recently, I think it was last week, maybe it was the week before at this point. So the university decided to allow Atkerson now to speak with students anywhere on campus when they invite him to have a conversation. This shouldn't be particularly controversial, but it did take litigation, or I don't know that it was actually a filed lawsuit. I think it was just a strongly worded letter from the First Liberty that got Georgia State to back down. So it's a victory for free speech and free exercise of religion, but it does seem to be a limited one. It seems that this was a particular resolution for Mr. Atkerson saying he could speak to students. They weren't going to enforce these free speech zones, but it appears that the free speech zones and restrictions on speech still apply on the campus. So those are the facts. Just a couple of thoughts, and then I'll turn it over to you because I'd like to hear your thoughts too. But I'd say, first of all, traditionally, the public commons are a place of robust exchange, right? This is where political and religious discussions happen, right? You think of like the pre-internet, pre-television days, the public square, right? The public park, and so on. That's where you have these conversations, and it's why we have a First Amendment, particularly to prevent, right, restrictions on controversial speech, on religion, on politics. Is exactly why the First Amendment exists. So it's important to distinguish public and private places, right? On one hand, a state university is not the same thing as a public park, right? A public park is just for the public to be in peacefully, period, right? There's not really like an agenda there. A state university is a little different, right? People go to class, they go to lecture halls. So limited restrictions make sense, right? There's an interest in ensuring that like if students are going into their lecture halls or into the library to study or to hear a lecture, that maybe Christian preachers don't belong there speaking to students while they're like going to lectures, right? I get it. But beyond that, when you're talking about like the campus commons, right, the outdoor spaces, even the indoor spaces that are just kind of public halls and things like that, uh, I think you're on dicey ground banning religious speech or political speech or really speech at all, especially again in the outdoor places. These, to me, you're not interrupting lectures, you're not interrupting students from studying. These are essentially public square type places. So I think in places where the person speaking about religion or whatever it is, if they're not distracting students from a lecture or from their studies, I do think that this kind of banishing to free speech zones is kind of akin to banning discussion of like religion or politics from a public park or a meeting place, or saying like, this picnic bench only is the free speech zone in this public square. Again, this is precisely what the First Amendment is meant to protect against. this is not a private college, even when you have private colleges, as we've seen before in recent cases, right? Like the affirmative action cases. If you're a private university, but you're taking a lot of public federal funds, then you might be on the hook to abide by some of these First Amendment issues anyway. But that doesn't even apply here because, again, Georgia State is a public university. Um, so I think it's interesting. I'll leave it with this. First Liberty in their statement put it well. I think just pointing out how obvious a case this really is, right? They said, our attorney sent a letter urging the university to reverse its overbearing restrictions. We explained that Americans don't need government permission when two people want to have a conversation about religion. The First Amendment protects the free exchange of ideas, all ideas, end quote. So I think it really is as simple as that, right? If two people are in publicly funded space and they want to have a conversation, for a government actor like a state university to say, no, you have to be in this little bubble zone, you may not leave the rain from this bubble zone and go under shelter to talk about First Amendment protected speech. It's wild to me that this became an issue, and I'm grateful to see that First Liberty was so aggressive and got a quick resolution to this one.
Yeah, I this is such an interesting case, and it's a little bit disturbing, I think, just because of it's just so symptomatic of the ill health in the higher education system that this happened, because all that I can think of is the October 7th situation, and then the overt hate speech against Jewish students, the overt violence, the harassment, the fear. And all of that is, put in a gray area where we had the university presidents testifying before Congress, not being able to say whether, you know, genocide violated their hate speech policies. And yet we have this, well-meaning student having a rational discussion about first things with another student, and they're being approached by armed guards. It's just so disordered that the armed guards are not protecting, or I hope it's gotten better, but we're not protecting students against authentic hate crimes. But then a fair-minded discussion about first things is not only being discouraged, but actually approached by armed guards at a public university. I mean, if this isn't the kind of conversations the universities want to have happening on their campuses, we are just in such deep trouble that sort of genuine hate speech, genuine harassment is going unpunished, and then serious dialogue about first things that matter is being approached with literal armed guards. It's just um, really disturbing, I think, and I'm glad First Liberty persuaded the university. But as you said, it's a bit of a limited victory, and there's something, to borrow a term, there's something systemic that needs to change here.
Yeah, absolutely. And I'll just say this too, from a practical perspective. This has to be such a targeted thing, right? Because first of all, Georgia State, this is not like a tiny private university, right? Like I wonder how many students are at a place like this. They're probably tens of thousands. It's a public, state research university. So I mean, Mary Margaret, you've been to college campuses, right, to give guest lectures where you're not a student, you're not faculty, you don't have any reason to be there other than maybe you were invited to do something, but we walk on university commons all the time. Like there are no people with guns walking around patrolling to make sure you're in a free speech zone, right? I've been sat on bin benches. I've been in coffee shops of universities, public and private. I've never had anybody police the kind of speech I've engaged in and what area of the campus it was in. Again, it's different if you wander into a lecture hall while there's a lecture going on, but otherwise, just this level of behavior at a university is just it's so obviously targeted because nobody acts like that on a university. There are all kinds of characters having all kinds of conversations all over campuses throughout the country. So this is really shocking. And I guess it's not as natural of a transition, but maybe speaking of shocking things, we're gonna wrap up by talking about transgender drugs and surgeries for minors. So unless you have anything
Yes.
else on the Georgia State one, I'll let you take it away.
Well, closing comment, I have to say at Texas A&M, we did have Ask an Aggie Catholic, which was people from the Catholic Center at St. Mary's would wear like, I think they were pink or blue t-shirts that said "Ask a Catholic," and you could go and ask them questions if you were a student, and other denominations did that as well, other faiths, and it was very vibrant, and there was a lot of, like, good morale that was built around these interfaith dialogues, and it allowed students to learn from each other. It was really, honestly, probably the most vibrant, healthy example of dialogue that I saw my entire time as a student, and so, I think this if we had been at Georgia State, we would have been approached by armed guards and told where to go. So I hope that changes because it's a really important opportunity. But yeah, so closing with some updates on the so we've spoken over the last few episodes about several of Trump's day one executive orders, including the one protecting minors, and then the one on gender identity or gender ideology. And it just sort of reminded me of the phrase, how it started, how it's going. So we talked about how it started with the executive orders, how it is going. The uh, State of Washington filed in Seattle District Court with a few other states, Oregon and Minnesota, challenging these two executive orders and specifically asking the court to grant a temporary restraining order that prevents the um, federal agencies from following through on what President Trump ordered. Um, and the Seattle District Court granted this request for a TRO. So in Washington, Oregon, and Minnesota, federal agencies cannot follow through on that executive order at this time. And then in Maryland, a nonprofit, the acronym is PFLAG. I can't recall exactly what it stands for. It is an LGBTQ rights nonprofit. Let me just see if I can find the full acronym. It's not immediately apparent to me. But anyway, so that this nonprofit challenged the same executive orders in Maryland and also asked for a TRO preventing enforcement. And that was granted for a period of 14 days. So that 14 days will end, I believe, this week on February 27th. So I thought that these two cases, the complaints or the requests for the TRO, and then the briefs opposing the motion for the TRO were kind of interesting. Both the Seattle and Maryland cases, they had some similar arguments and then some slightly different ones. So in Maryland, there were really three lines of argument. The first was that this I thought was sort of endearing, that it violated separation of powers. The reason I thought that was a little bit funny is because historically, secular progressivism has not really been particularly concerned about separation of powers. But here we are. And then the second was an equal protection claim, which I'll talk a little bit more about in a minute. And then thirdly, statutory sex discrimination. So saying that the executive orders contradicted federal legislation, specifically 1557 of the Affordable Care Act and Section 6 of the Civil Rights Act, as interpreted by the Supreme Court in Bostock. So basically, the Maryland plaintiffs were saying violates separation of powers, violates equal protection, and contradicts existing federal law, and federal law should trump. So, if you will, that was no pun intended. And then the Seattle plaintiffs are arguing equal protection as well as, and additionally, a 10th Amendment claim, which is another one that's historically not been the secular progressive movement's favorite amendment. It's, the powers not delegated to the federal government are reserved to the states. And then in a particularly kind of amusing quote said that the federal government has no right to regulate medicine, and that it was not it is not an enumerated power. So I have so many questions about that. I think a lot of people from more of a conservative legal standpoint might agree with that. But I have a feeling that line of argument's not going to be developed to its natural conclusion. And then I want to speak briefly about what the opposition said to refute those arguments, and then again just touch briefly on the equal protection argument. So the equal protection doctrine is derived from the Due Process Clause in the Fifth Amendment, and it basically the equal protection doctrine basically holds that it would be a violation of due process of law for one group or one individual to be denied what's provided to a similarly situated group or individual, particularly on the basis of some classification. And certain classifications, the Supreme Court has said, are highly suspect. So the bar is going to be more stringent when one group is denied something that another group's being given, if the basis for the denial is this particular suspect classification. So, of course, the typical kind of protected classes of race, color, or national origin, religion, and sex go into those heightened areas. And so, what the plaintiffs are saying here is that Trump's executive order is denying trans identifying minors certain medical care, and that other minors are not being denied that medical care, and that they're denied the medical care they need or desire, and that the reason for that denial is the minor's transgender status. And then the conclusion to that argument is that that's not an important reason for the government to be distinguishing between those groups, and it's not related to a substantially, or it's not substantially related to an important government objective. Um, so what the Trump administration is saying in defense is, first of all, this is not that it's not out of scope of authority for the executive branch to issue these regulations. And that it's not a violation of equal protection because these are minors, and that the distinctions are rationally related. So the slightly different standard that the Trump administration's putting forward, rationally related to the important government purpose of protecting the health of minors and the truth about their medical needs. So I think we'll have some answers this week as the first TRO expires, and then in the coming weeks as the Seattle TRO um, court date comes. I think it was actually February 20th that some of the intermediate documentation was done, so we'll probably get some more clarity in the next few days. But some really interesting cases. Um, and yeah, I guess I'll close with this last update. Just so this is what's going on, kind of in the legal system. What's happening on the front lines, kind of as they say in real America. Um, in real America, legislators in Kansas recently overrode a governor's veto of a bill that banned transgender surgeries, or what the Trump administration calls surgical mutilation of minors. And so the governor uh, vetoed the bill, meaning that those procedures would have gone on. And the legislature said, no, we weren't kidding. This is not something that the people of Kansas want for our children. They overrode the veto, and now these practices on minors are prohibited. And it's worth noting this vote was 94-35 in the House and 31-9 in the Kansas Senate. So really interesting split. Yeah, what are your thoughts, Frank? There's a lot here, both on the injunctions and then on the Kansas developments as well.
Yeah, on the Kansas one, I'll just say that I think it's a fascinating political reality. I won't comment on exactly why, but I think the fact that you have Governor Laura Kelly, who vetoed the transgender ban, the transgender procedures for minors ban. She's a Democrat, and so it's just an interesting reality to me that you have states that have a Democrat governor, but then veto-proof Republican supermajorities in both houses. It's just an interesting political makeup. You usually states that are that deep red wouldn't have like certain branches of government run by the other party, and there are several reasons that that can be the case, but that's beyond the scope of this conversation. I just think it's interesting. On the federal, the executive order and the TRO. I mean, I have a lot of thoughts. For the sake of brevity, I'll just point out a couple things. I think one, it's interesting. You pointed out that people on the left who are now supporting these lawsuits against the executive orders are making claims like, federal government doesn't have the power to legislate or to ban medical procedures. This is not the domain of the federal government. You're right. There's kind of a rich irony to that. But the other thing is there's just an obvious confusion about legally what's going on here, right? That the administration's not banning these procedures. It's choosing to withhold funding, which is obviously within its power because that we have a federal government that funds, right, state and local health networks in this case, but that funds state and local everything. So this is just kind of a fruit of the system that we now have with high federal taxes and high federal funding that's distributed to everything. The Trump administration did not ban transgender surgeries for minors. That probably would be beyond the scope of federal power. But what it's saying is, well, we currently give money to hospital networks and to doctors and to research universities for medicine. We're not going to give that money if they're doing these kind of procedures on minors. That's clearly within the federal power because the federal government is funding these things. So choosing not to fund something is obviously a federal power. Um, the other thing I'll say that I think it was pretty clear if you read the original executive order, which we went over on this podcast a couple weeks ago. The problem here, this was not about discrimination against transgender identifying people, right? It's clearly it was spelled out in the order. This is about the problem of what the administration called junk science and the dangerousness of these procedures on, especially on minors who are still developing. Um, I think the idea that this is anti-trans, and I put that in scare quotes, discrimination I think you mentioned this, is obviously not the case because there's no ban on funding for medical organizations that do these transgender procedures on adults, right? So it's clearly not meant to target trans people. It's clearly meant to target um, controversial and problematic procedures on minors, period, right? So unless you're going to make minors the protected class, and then like you said, then we're not talking strict scrutiny, because it's not where, yeah, anyway, I think I'll just leave it there, but I think it's fairly obvious that the intent, both on the face of the executive order and just common sense, is not to discriminate against people who identify as trans. It's to stop funding things that are not settled science. That there are procedures where there are a lot of red flags, and so to experiment on minors with unproven remedies, it's clearly within the federal government's purview to stop funding these things. So I suppose with that, we will wrap up. So, as always, thank you for joining us for this episode of the Napa Legal Podcast. If you listening enjoy the content we're putting out, we would appreciate it if you like our podcast and subscribe to our channel on YouTube, Spotify, or wherever you are listening. So we hope you'll join us next week as we continue to dive into some of the most important ongoing legal issues that affect religious liberty and the work of faith-based nonprofit organizations.
We'll talk to you all next week. Thank you for joining us, and may God bless.